Hi, welcome to my presentation titled Privacy and Civil Liberties Protections in EU and US Artificial Intelligence Regulations. The key question I want to address through this project is, how do differing approaches in the EU and the US influence the development of AI regulations, and how can these frameworks effectively address and anticipate emerging challenges in privacy and civil liberties? AI is transforming technologies by automating tasks and enhancing processes that were once reliant on human effort. But with this transformation raises major privacy and ethical concerns. Regulators worldwide are grappling with how to regulate AI effectively. I chose this topic as it reflects my professional and personal interests. As a cybersecurity auditor, I've witnessed firsthand the growing integration of AI tools into workplace environments, and it's prompted me to reflect on the ethical challenges of using AI. Additionally, I'm interested in human rights and comparative law, having worked at the United Nations with an educational background in law. To answer the key question, the following topics will be explored. First, an overview of AI's impact on privacy and civil liberties. Privacy refers to individuals' ability to control their personal data, which becomes increasingly important as AI processes and analyzes that data for decision making. Civil liberties are also at stake, including protection from discrimination and freedom from government interference, particularly with technologies like AI-driven mass surveillance and automated decision making. The second topic is on challenges in establishing effective AI regulations. One of the biggest hurdles in regulating AI is its rapid evolution. AI develops faster than legal frameworks can adapt. Another complexity is its broad scope. AI is not just a new technology, but often enhances existing ones. The real issue isn't always the technology itself, but how and by whom it's used. Adding to this, regulators must balance two competing goals: protecting fundamental rights while encouraging innovation. The third topic is on comparison of EU and US AI regulatory approaches. By comparing the regulatory approaches of EU and the US, we can see the strengths and weaknesses of each system. Lastly, I will explore the future of global AI regulations. Will the EU AI Act become a global standard, much like GDPR did for privacy laws? I'll also explore how AI regulations in the US could change with the new conservative government in power. Let's explore some examples of privacy and civil liberties concerns related to AI. First, algorithmic bias poses a direct threat to the principles of equality and non-discrimination, which are fundamental to human rights. Bias in AI systems can reinforce and even amplify systematic inequalities. For instance, in hiring practices, AI systems must not discriminate based on gender or ethnicity. This was highlighted in cases like Amazon's AI hiring tool, which had to be scrapped after it was found to favor male candidates. Second, opaque AI systems undermine rights to due process and freedom from arbitrary decision-making. For example, credit scoring algorithms must explain why a loan application was approved or denied, ensuring accountability. Third, excessive surveillance by states erodes fundamental civil liberties, including the right to privacy and freedom of expression. Finally, AI systems often handle vast amounts of private and sensitive data, making the protection of this information critical. Without robust data protection, individuals risk losing their privacy, autonomy, and even security. Let's talk about some of the biggest challenges when it comes to regulating AI. First, one of the toughest tasks is staying ahead of AI's rapid evolution. New applications are constantly emerging, and we need regulations that are flexible enough to adapt to those changes. Next, there's the challenge of finding balance. On the one hand, we need to protect privacy and civil liberties, but on the other hand, we want to encourage innovation. Striking that balance is easier said than done. Finally, we must consider the relevant regulatory landscapes. While the EU harmonizes laws across member states through overarching regulations implemented at the regional level, the US struggles with fragmented and inconsistent approaches due to state autonomy, federal inaction, and partisan political divides that hinder a unified regulatory framework. The EU AI Act officially came into force this year, but its provisions will take effect at different times. If an AI system interacts with the EU market or its people in any way, whether you're based inside or outside the EU, you must follow the EU's rules. The AI Act categorizes AI systems into 4 distinct risk levels, ensuring that regulatory requirements are appropriately tailored to the level of risk associated with each category. AI systems presenting unacceptable risk are strictly prohibited. High-risk systems are subject to strict oversight because they significantly affect safety or fundamental rights. Limited risk systems face transparency obligations, such as informing users when interacting with AI. Minimal risk systems have no specific requirements, covering systems like video games or spam filters. The EU AI Act explicitly bans AI systems that pose unacceptable risks. These include exploitation of vulnerabilities. This refers to AI exploiting vulnerabilities based on age, disability, or socioeconomic conditions to distort behavior and cause harm. For example, online platforms which have targeted gambling ads to recovering addicts or children, exploiting their vulnerabilities. Predictive criminal profiling. This refers to AI used solely to predict potential criminal activity based on profiling or personality traits, raising fairness and bias concerns. Social scoring. This refers to systems that evaluate individuals based on their behavior, traits, or inferred characteristics, leading to unfair or detrimental social treatment. For example, China's social credit system assigns citizens scores based on their behavior, impacting access to jobs, loans, and travel. Unlawful facial recognition. This refers to AI systems creating or expanding facial recognition databases through untargeted internet scraping or unauthorized CCTV footage. For example, Clearview AI scraped billions of photos from social media platforms without consent, and European regulators fined the company for violating privacy laws. Real-time biometric identification. This refers to facial recognition in public spaces for law enforcement purposes, except under strict conditions, for example, when locating abducted individuals. For example, Moscow's public surveillance network used facial recognition during protests, sparking criticism about privacy violations and government overreach. Biometric categorization. This refers to categorizing individuals using biometric data to infer sensitive attributes like race or religion, with exception for lawful purposes in law enforcement. For example, in some airports, biometric systems have disproportionately flagged minority travelers for additional screening, raising discrimination concerns. Manipulative AI. This refers to systems using subliminal, deceptive, or manipulative techniques that impair decision-making and cause significant harm. For example, Cambridge Analytica leveraged user data and psychological profiling to manipulate voter behavior during elections, undermining democratic processes. Although this example involved big data analysis rather than AI, it remains a good example of how technology can manipulate decision-making, and the same concept applies to AI-driven systems. Emotional inference. This refers to AI designed to infer emotions in workplaces or educational settings, unless used for specific medical or safety purposes. For example, AI in job interviews like HireView analyze emotional cues to evaluate candidates, leading to concerns over bias and unreliable assessments. High-risk AI systems, while not banned, are subject to stringent regulatory requirements because of their potential to significantly affect individuals' health, safety, or fundamental rights. Under Article 6, AI systems are high risk if they relate to safety critical areas or fall under Annex 3 categories. I'll go through each of the Annex 3 high-risk categories. Biometrics. Critical infrastructure. For example, AI systems used in managing energy grids to prevent outages. Education and vocational training. This refers to AI determining access to education or monitoring students. Employment and self-employment. This refers to AI in hiring or employee evaluations. Access to essential services. This refers to AI assessing eligibility for public and private services like healthcare, loans, or insurance. Law enforcement. This refers to AI used for profiling, risk assessments, or polygraphs. Migration. This includes AI aiding migration and border control, such as for making visa decisions. Judicial and political processes. This refers to AI used in legal decisions or elections. There are exceptions, however. Systems mentioned in Annex 3 are not deemed high risk if they don't pose significant harm or materially influence decision-making. A good example is an AI-powered audio transcript used in legal or administrative document preparation. Moving on from high-risk systems, other AI systems which are considered limited or minimal risk are primarily subjected to transparency obligations. Companies deploying such systems must ensure that AI-generated content is clearly labeled. Lastly, regarding enforcement and penalties, the EU AI Act enforces a tiered penalty system to ensure compliance. Fines can be up to 35 million euros or 7% of global turnover for prohibited practices. Now let's talk about the current state of AI regulation in the US. At the federal level, we don't yet have any AI-specific laws. Instead, we're relying on privacy and consumer laws and sector-specific laws like those governing healthcare or finance. On the state level, we're seeing some emerging legislations. For example, Colorado introduced the Colorado AI Act, which emphasizes algorithmic fairness, ensuring that AI systems treat people equitably. It regulates high-risk AI systems in areas like employment, education, financial or lending service, essential government service, healthcare services, housing, insurance, and legal service. It mandates safeguards against algorithmic discrimination and requires transparency. In terms of penalties, the Colorado's AI Act imposed civil penalties up to $20,000 per violation, counted separately for each consumer or transaction involved. New York also passed the Automated Employment Decision Tools Law, which is particularly relevant for hiring practices. It requires companies to conduct bias audits of their AI hiring tool. Bias audits are independent evaluations conducted to assess whether an AI hiring tool unfairly discriminates against certain groups of individuals based on characteristics like race, gender, or other protected attributes. Non-compliance can result in users being fined up to $500 for the first violation and $500 to $1,500 for subsequent violations. Californian privacy laws now include specific provisions related to artificial intelligence, with new amendments introduced this year. Any AI-generated data about a person is considered personal information. For example, if a bank uses AI to predict a customer's creditworthiness and outputs a profile, this AI-generated profile is considered personal information. Penalties include up to $7,500 per intentional violation. I should note here that none of these US penalties come close to the stringency of the EU AI Act. Also, the US regulations tend to penalize the users, whereas the EU AI Act primarily focuses on penalizing developers, providers, and deployers of AI systems. This leads to a more reactive, tech-specific or sector-specific regulation in the US, while the EU adopts a proactive, systemic governance approach targeting the entire AI lifecycle. But I'll come back to the comparison of the two systems later. Here's a quick look at California's new AI laws, once again with penalties far less strict than the EU's. The Healthcare Services Artificial Intelligence Act, which requires disclaimers for AI-generated patient communications. The Defending Democracy from Deepfake Deception Act, which mandates large online platforms to identify, block, and label deceptive AI-generated election-related content. And the California AI Transparency Act, which mandates public-facing AI systems with over 1 million users to disclose when content has been generated or modified by AI. On the federal side, there are a few noteworthy proposals. I have them on the slide for your reference, but I won't go over them because they may be less relevant now with a changing government. To give an example, an executive order was made under Biden in October 2023 to provide policy guidance on AI, ensuring safe and ethical AI development. But Trump has signaled his intention to rescind it, describing it as a dangerous executive order that hinders AI innovation and imposing radical left-wing ideas on the development of AI. This signals a significant shift in US AI regulation, with the Trump administration likely prioritizing deregulation to promote innovation. Earlier, we talked about the key challenges in regulating AI. This slide brings us back to those challenges and explores how the EU and the US approach them. Starting with anticipating future AI applications, the EU takes a comprehensive risk-based approach with the AI Act to proactively address potential risks. The US, by contrast, relies on more state-level regulations which are technology-specific and sector-specific, providing flexibility but lacking a unified strategy. Next, when it comes to balancing privacy, civil liberties, and innovation, the EU is rights-focused and proactive, prioritizing ethical considerations and user protections, but this could impact innovation due to strict regulations and high penalties. On the other hand, the US emphasizes innovation, often taking a more reactive approach, which can leave regulatory gaps in addressing civil liberties and privacy concerns. In relation to regulatory landscapes, in the EU, there's a strong focus on ensuring that laws and regulations are the same across all member states. The EU AI law directly applies to all EU countries, ensuring consistency across the bloc. In contrast, in the US, the individual states have significant autonomy to draft their own laws, and the federal government has largely remained inactive on comprehensive AI regulation. This may lead to fragmented and inconsistent approaches to AI governance. Finally, in terms of enforcement and penalties, the EU has introduced high penalties for non-compliance to ensure accountability and adherence to its regulations. The US, in comparison, has more limited enforcement mechanisms, which can weaken its ability to ensure compliance. With the new conservative government in the US, we can expect a shift in AI regulation priorities. The focus is likely to be on fostering innovation and economic growth and a less regulated approach to AI. Economic and technological competitiveness will be prioritized while potentially sacrificing long-term safety, privacy, and civil rights. This means the US is less likely to align with the EU's rights-focused, transparency-driven framework. Instead of the EU's proactive, harmonized approach, the US may continue to lean towards sector-specific and technology-driven regulations. While this provides flexibility for industries, it may not adequately address broader societal concerns like privacy and civil rights. Federal legislation may take a backseat, with states continuing to lead AI regulation efforts. This decentralized approach reflects conservative values of limiting federal oversight and prioritizing state autonomy. As a result, we might see a patchwork of regulations across the US, making compliance more complex for businesses operating nationwide and creating a stark contrast to the EU's unified framework. The EU AI Act has sparked a global debate on how AI should be regulated, raising the question, will the EU AI Act become the global standard? Whether states worldwide adopt regulations similar to the EU AI Act will largely depend on their core values and priorities, specifically whether they prioritize innovation or rights protection. Countries that share the EU's focus on fundamental rights and ethical governance are more likely to adopt a regulatory approach similar to the EU's. Conversely, countries that prioritize economic growth and technological innovation are more inclined to align with the US approach, which emphasizes minimal regulatory constraints. Ultimately, the choice each country makes will reflect its cultural, economic, and political priorities, balancing the need to protect individual rights with the drive to advance technology. That brings us to the end of the presentation. Thanks for listening.